Good day, dear students. In this video, we shall see about the presidential and parliamentary governance forms, the various offices that are prescribed by the Constitution of India for the presidential and parliamentary governance forms. What are the roles and responsibilities of the union executives? How the union executives are elected? What is the minimum required qualification to be eligible to contest for the house or the office of the union executive? How the power is shared and the responsibilities are shared between the various officers of the union executive will be seen in this video. This module covers the parliamentary system of the Government of India, the federal system. What do we mean by parliamentary system and federal system? How the state and center relationships are defined and how the power sharing between the state and center takes place. The union executive offices like the office of the president, vice president, prime minister, union cabinet, the roles and responsibilities of parliament, that is Lok Sabha and the Rajya Sabha. What do we mean by parliamentary committees and how they are formed, and the various requirements for holding the office of the above mentioned officers will be explained in this module, will be covered in this module. In the second part of this module, we shall see about the Union Judiciary, that is how Supreme Court of India is formed. What do you mean by judicial reviews and judicial activism? How the state executives, that is the governor, what are the roles and responsibilities of the governor, how the office of the governor is elected, will be seen in this second part of the module 2. We shall also see the roles and responsibilities of the chief minister, who are the cabinet of the cabinet of the chief minister. What is the roles and responsibility of the cabinet of the chief minister? What do you mean by state cabinet and the state legislature, and how high courts and subordinate courts are formed and function will be seen and covered in this module. You should also see towards the end of this chapter the special provisions, that is Article 370, Article 371 and Article 371J, that are applicable for some of the states in our union. These articles will explain about the special powers that is given to the different states as per the requirement of the region of that particular state. So we have a presidential and parliamentary governance forms. The a government is an organization or a machinery or an agency through which a political party or a political unit will exercise its authority, control and administer the public policies and governance, and it will direct and control the actions of its citizens. So, political party has to be a part of the government, and only through the government they can exercise all these authorities. So, the government can make laws, regulate economies, conduct relationships with neighboring countries. They can maintain relationship with the neighboring countries, provide infrastructures like hospitals, schools, roads, highways, and services to the common citizens. A government is required to maintain an army and a police force on behalf of the people of the country. A democratic government is the one that is opposed to an authoritative government. In democratic government, the citizens are directly participating in the formation of government, whereas in authoritative government, the inclusion of the citizens in the formation of the government is less or comparatively lesser as compared to the democratic form of government. And democratic form of government is always better as compared to the authoritative form of government. Also, democratic form of government is better than anarchy, where no form of government or no governance is present. A democratic government ensures that people directly participate in the formation of the government. Democratic governments are the ones that permit the nation's citizens to manage their governance, either directly or through elected representatives. One of the fundamental aspects of constitutional design is the choice between presidential government, parliamentary government, and a hybrid system that combines both the aspects. The main difference between the presidential and parliamentary system of governance is the result of how the state executives and legislatures and the judicial organs are organized. In India, the three units, that is the executive, the parliament, and the judiciary, are three independent units. The United States has a presidential system, as do the countries which United States has influenced regionally, culturally, or militarily. With the exception of United States, presidential system is often been associated with politically unstable and authoritarian regimes. Countries that have adopted a form of parliamentarianism include the United Kingdom and much of the European countries, Israel, Japan, many former British colonies in Africa and Asia, and most of the Caribbean countries. However, there is one more system, that is the hybrid system, that is followed by the French. So the French hybrid system has provided a model for many other countries wherein both the presidential and the parliamentarian system is given due importance and power sharing between the two is clearly visible. The key differences among the three systems, that is the presidential system, the parliamentary system, and the hybrid system, include the extent to which the power of governments are separated functionally between the three branches, and in the powers one branch does or does not have over the another. These include the extent to which executive can control the legislative assembly or the legislative branch, or the extent to which the legislative can control the executive, and the extent to which the legislative branch controls the capacity to legislate. One important area of control and competition is the capacity to introduce and approve legislation, and these vary considerably among all the three systems. In presidential system, political and administrative powers are divided between the executives, legislative, and judicial branches, and officials in these branches serve different terms of office and represent different constituencies. In parliamentary system, parliament is sovereign and executive authority, and the power of the parliament is exercised by the prime minister and his cabinet. and the power derived from the Parliament through the legislature empowers the Prime Minister to make necessary laws and clear the necessary improvement, create necessary improvements in the country. In a hybrid system, executive power is shared between separately elected president and a prime minister. The union executive consists of various posts. The first one and the primary posters of the president. So, as per the constitution, there shall be a president of India. The executive power of the union shall be with the president of India. The executive power of union shall be vested in president and he shall exercise either directly or through various officers who are subordinate to him, and this will be in accordance with the constitution by abiding by all the rules and regulations of the constitution. Without prejudice to generality of the foregoing provisions, the supreme command of the defense forces of the Union shall also be the President, and he shall exercise the command, and it is regulated by law. The literal meaning of this is he is in charge of the defense forces of the country, that is army, the navy and the air force. However, nothing in this article shall be deemed to transfer the president any function conferred by any existing law on the government or any state or any other authority, or prevent parliament from conferring bylaw functions on authorities other than the president. Okay. The election of president is through an electoral college. The president is elected by the members of the electoral college, and this electoral college shall consist of people from the House of Parliament or the Lok Sabha and Rajya Sabha, and elected members of the Legislative Assembly of the states, that is the Vidhana Sabha. The manner of election of the president is explained as below. As far as possible and as far as practicable, there shall be uniformity in the scale of representation of different states at the election of the president. For the purpose of securing such uniformity among the states, as well as to attain the parity between the states as a whole and the union, the number of votes which each elected member of parliament and the legislative assembly of each state is entitled to cast at such election shall be determined in the manner as explained below. For every elected member of the legislative assembly of the state, there shall be as many votes as there are multiples of 1000 in the quotient obtained by dividing the population of the state by the total number of elected members of the assembly. So the literal meaning is the population of the state and the members of the assembly has a direct relation to the number of votes that can be cast by the member of that legislative assembly. Even after taking the said multiple of 1000, the remainder is not less than 500. Then the vote of each member will be further increased by 1. So it will be converted to the nearest whole number if it is above 500. Each elected member of either house of the parliament shall have such number of votes and may be obtained by dividing the total number of votes against the assigned members of the legislative assembly of the state, and the total number of elected members of both the houses of parliament, fractions exceeding one half being counted as one and other fractions being disregarded. Means if it is less than 500 or less than 0.5, then it will be disregarded. The election of president shall be in accordance with the system of proportional representation by means of single transferable vote, and voting at such elections shall be through secret ballot. These are the norms given for the election of the president, which are clearly specified in the Constitution of India. The term for the office of the president. Once elected, the president shall hold the office for a term of 5 years. So 5-year term has been fixed as the term for the president of India, provided that he should not resign from his office. He can hold the office of president for a period of 5 years, provided he should not resign from the office. Second condition is, for the violation of the constitution, he can be impeached as per the article 61. If there is violation of the constitution by the president, then there is a chance for his impeachment and removal from the office of the president as per the article 61. The president shall which notwithstanding the expiration of his term, continue to hold office until his successor enters upon his office. So the moment his successor comes into his office on expiration of his term, until then he can hold the office of the president. And one more case is, if any resignation is addressed to the vice president as per the clause A, then it has to be communicated to the Speaker of the House of the People. It has to be communicated to the Speaker of the House of the People. Next is eligibility of re-election. A person who holds or who has held office of the president shall be eligible and subject to the other provisions of the constitution be eligible for re-election of the office again. So a person who is already a president can be elected as a president, provided he has all the eligibility as mentioned in the constitution. Okay. Qualification required for election of the president. He shall be eligible for election of a president provided he fulfills the following requirements. That is, he should be a citizen of India. He should have completed at least 35 years of age. He should be qualified for election as a member of the House of the People. Either he should be qualified to become a member either for Lok Sabha or the Rajya Sabha. And person shall not be eligible for election as president if he holds any office of profit under the government of India, or if the government of any state, he holds any office under the government of any state, or if he holds office under any local or other authorities of the country. This module covers the parliamentary system of the government of India, the federal system. What do we mean by parliamentary system and federal system? How the state and center relationships are defined, and how the power sharing between the state and center takes place. The union executive offices like the office of the president, vice president, prime minister, union cabinet, the roles and responsibilities of parliament, that is Lok Sabha and the Rajya Sabha. What do you mean by parliamentary committees and how they are formed, and the various requirements for holding the office of the above mentioned officers will be explained in this module, will be covered in this module. The procedure for impeachment of the president is also clearly mentioned in the Constitution. The Constitution reads as below: when a president is to be impeached for violation of the Constitution, the charge shall be preferred by either house of the Parliament, and no such charge shall be preferred unless the proposal to prefer such charge is contained in a resolution which has been moved at least 14 days notice period and in writing and signed by not less than one-fourth of the total number of members of the House, and has been given to their intention to move the resolution. So at least 25% or one-fourth the members of the House have to pass the resolution, and 14 days notice period has to be provided before such an act of impeachment is introduced in the House. When such resolution has been passed by a majority of not less than two-thirds of the total membership of the House. So at least two-thirds or 66% of the members have to accept this resolution. In only that case, the impeachment is possible. So when the charge is introduced in the House of the Parliament and it is referred by one-fourth of the strength of the Parliament and approved and passed by two-thirds the strength of the Parliament, in such cases the other house shall investigate. That is, if it is preferred by either house of the Parliament, either by Lok Sabha or the Rajya Sabha, then the other house, if it is preferred by Lok Sabha, then Rajya Sabha shall investigate. If it is preferred by Rajya Sabha, then Lok Sabha will investigate the charge, and the cause of charge shall be investigated, and President shall have the right to appear and be represented at such investigations. If, because as a result of the investigation, a resolution is passed by a majority of not less than two-thirds of the total members of the House by which the charge was investigated or caused to be investigated, declaring that the charge preferred against the President has been sustained, such resolution will have the effect of removing the President from his office from the date on which the resolution is passed. After the investigation, if President is found to be guilty of not adhering to the rules of the Constitution, then he can be impeached. So the procedure for impeachment of the president is clearly mentioned in the constitution without any ambiguity. The time period for holding election to fill the vacancy in the office of the president and the term of his office for a person who is elected to fill casual vacancy. So an election to fill the vacancy caused by expiration of the term of the president will be completed before the expiration of the term. Well in advance, the election has to be completed. The election to fill the vacancy of the president occurring by reason of his death or his resignation or removal by impeachment or due to some other reasons shall be held as soon as possible, and in no case less than 6 months from the date of occurrence of the vacancies. So beyond 6 months, the seat of the president, the post of the president cannot be vacant. If the expiration of the term is going to happen, then election will be held well in advance. If it is happening due to certain unavoidable circumstances, then it should be held as soon as possible and it should not be delayed beyond 6 months. This is what the clause says. The next topic is the Vice President of India. The next executive in charge after the President is the Vice President of India. So India shall have a Vice President. The Vice President will be ex officio Chairman of the Council of the States. He will be the Chairman of the Rajya Sabha. And he shall not hold any other office of profit. The Vice President will be the Chairman of the Council of the States or of the Rajya Sabha, and other than that he shall not hold any office of profit. Provided that during any period when the Vice President acts as the President or discharging the functions of the President under the Article 65, he shall not perform the duties of the office of the Chairman of the Council of the States and shall not be entitled to avail any salary and emoluments and allowances payable to the Chairman of the Council of the States or Chairman of the Rajya Sabha under Article 97. So whenever he is acting as the President, whenever he is fulfilling the responsibilities of the President in the absence of the President, in such cases the Vice President shall not be the Chairman of the Rajya Sabha. He will not fulfill his duties as the Chairman of the Rajya Sabha. The Vice President shall act as President, or he will discharge the duties of functions of the President during casual vacancies in the office or during the absence of the President. In the absence of the President, Vice President will act as the President. Whenever an event occurs of vacancy in the office of the President by reason of his death, resignation, removal by impeachment, or due to some other unavoidable circumstances, the Vice President shall be acting as the President until the date when a new President is elected as per the provisions of the Constitution, and he fills the vacancy upon entering his office. So until the period a new person is elected as the President, Vice President shall take charge and responsibilities of the President. When President is not able to discharge his functions owing to absence due to illness or any other causes, then Vice President shall discharge his functions until the date on which the President resumes his duties. When and also the Vice President during and in respect of the period which is so acting as the President and discharging the functions of President will have all the powers and immunities of the President, and also he will be entitled to all the emoluments, allowances and privileges that will be determined by the Parliament by law, and until provision in that behalf is so made, such emoluments, allowances and privileges are to be specified or has specified in the second schedule. So whenever Vice President is acting or filling in the shoes of the President, he shall be getting the allowances of the President as determined by the Parliament. The process of election of the Vice President. The process of election of Vice President is also similar to the process of election of President. Here, the Vice President shall be elected by the members of the Electoral College, consisting of the members of both the houses of the Parliament. That is, the members of Lok Sabha and the Rajya Sabha will be the members of the Electoral College that will cast their vote in the Vice Presidential elections. Whereas in the presidential elections, the Electoral College consisted of the members of both the houses of the Parliament plus the members of the state legislatives. Whereas for the Vice President, the members of the state legislatives do not cast their vote. The seat of the Vice President, only the members of the both houses of the Parliament shall cast their vote. And the election for the election of the Vice President shall be through secret ballot, adhering to all rules of the election. Vice President shall not be a member of either of the House of Parliament or the House of the Legislature of any state. He shall be eligible for election as Vice President only if he fulfills the following criteria. That is, the person should be citizen of India, one. Second one, he should have completed at least 35 years of age. And third, he should be qualified for election as a member of the Council of States. He should be citizen of India, he should have 35 years, he should have completed 35 years of age, and he should be qualified to be elected to the Council of, as a member of the Council of States. A person shall not be eligible for election as Vice President if he holds any office of profit. So he should not hold any office of profit under the government of India or the government of any state or any local bodies and local authorities or any other authorities that is under the control of any of the forms of government, either the state government or the central government. The term for the office of the Vice President is 5 years from the date on which he enters his office, provided that the Vice President should not resign from his office by writing a letter to the President, and a Vice President should not be removed from his office by a resolution by the Council of States, that is Rajya Sabha, passed by a majority of all the then members of the council and agreed by the House of the People, that is by the Lok Sabha. But no resolution for the purpose shall be moved unless at least 14 days notice period is given for the removal of the Vice President. And Vice President shall, notwithstanding the expiration of his term, continue to hold office until his successor enters upon his office. So, Vice President is eligible to hold the office of Vice President for 5 years until and unless he does not resign, he is not removed by the Rajya Sabha or the Council of State, by giving 14 days prior notice and through the majority of the strength of the Rajya Sabha, and on his expiration of a term, a new vice president or his successor enters his office. Until then, he can hold the office of the vice president. The time for holding the election to fill the vacancy in the office of vice president and the term of office of the person elected to fill the casual vacancy is explained as below. So an election will be conducted to fill the vacancy caused by the expiration of the term of the office of the vice president, and it has to be completed before the expiration of the term, well in advance. And an election to fill the vacancy of the vice president occurring due to his death or due to resignation or due to removal or due to some other unavoidable circumstances shall be held as soon as this occurrence has happened, and the person elected to fill the vacancy will be entitled to hold office for a full term of 5 years from the date on which he enters his office. So once a person enters or takes charge as the vice president, he is eligible to hold the office for a total period of 5 years. Oath or affirmation of the vice president. So every vice president shall, before entering his office, make and subscribe before the president or some other person who is appointed by the president on his behalf. Discharge of president's function in other contingencies. So Parliament can make such provisions as it thinks fit for the discharge of the functions of the president in any contingencies that is not provided in this chapter. So vice president can take charge and discharge the duties of the president provided the parliament will make such provisions and thinks it fit for the vice president to discharge the functions. The matters relating to or connected with the election of the president and vice president are explained below. So all the doubts and disputes arising out of or in connection with the election of president or vice president shall be enquired and decided by the Supreme Court, whose decision is final. If the election of a person as a president or vice president is declared void by the Supreme Court, and then the acts that are done by him in exercise and performance of the power and duties of the office of the president or vice president on or before the date of the decision of the Supreme Court shall not be invalidated, and it will hold good even if he is removed from the office due to this declaration by the Supreme Court. And the provisions of this constitution, Parliament may by law regulate any matters relating to or connected with the election of president or vice president. So constitution gives us an option wherein the Parliament may regulate the election of the president and vice president. Election of a person as a president or vice president will not be called in question on the ground of the existence of any vacancy or whatever reason among the members of the electoral college electing him. The vice president shall act as president, or he will discharge the duties of functions of the president during casual vacancies in the office or during the absence of the president. In the absence of the president, vice president will act as the president. Whenever an event occurs of vacancy in the office of the president by reason of his death, resignation, removal by impeachment, or due to some other unavoidable circumstances, the vice president shall be acting as the president until the date when a new president is elected as per the provisions of the constitution, and he fills the vacancy upon entering his office. So until the period a new person is elected as the president, vice president shall take charge and responsibilities of the president. When president is not able to discharge his functions owing to absence due to illness or any other causes, then vice president shall discharge his functions until the date on which the president resumes his duties. When and also the vice president during and in respect of the period, the extent of executive power of the union. This slide we shall see about the executive power of our country. So subject to the provisions of the constitution, the executive power of the union or our country shall extend to matters with respect to which parliament has the powers to make laws and to exercise such rights, authority and jurisdiction that are exercisable by Government of India by virtue of any treaty or agreement, provided that the executive power referred in the subclause above, and it shall not save as expressively provided. In this constitution or any law made by the parliament extend in any state to matters with respect to which legislature of the state has also powers to make laws. That means only the parliament can make laws, the state legislatures cannot make laws. Until otherwise provided by the parliament, a state and any officer or authority of the state may, notwithstanding anything in this article, continue to exercise the matters with respect to the parliament has powers to make laws for that state. Such extensive power or functions has the state or officer or authority could exercise immediately before the commencement of the constitution. The next part is Council of Ministers. So there shall be a Council of Ministers to aid the President in his administrative activities. So the Council of Ministers will be headed by Prime Minister, and he will advise the President, who will exercise his functions in accordance with the advice of the Prime Minister. Provided that the President may require the Council of Ministers to reconsider such advices either generally or otherwise, the President shall act in accordance with the advice tendered after the reconsideration. So there will be Council of Ministers who will aid President in administration. And the question whether any or if so advice was tendered by any minister to the President, it shall not be inquired in any of the court. So whatever happens between the Council of Ministers and President cannot be inquired in any of the court. The next office is the office of the Prime Minister. So the Prime Minister is generally the leader of the party or the coalition parties that has the majority in the Lok Sabha, that is the lower house of the Parliament of India. And the Prime Minister has to be a current member of either one of the houses, that is either Rajya Sabha or the Lok Sabha, or be elected within 6 months of being appointed as the Prime Minister. The powers and responsibility of the Prime Minister is explained as below. The Prime Minister selects the members of the Council of Ministers. He can choose who can be in the Council of Ministers and who will aid him in the administration and who will help him in administration, and they are formally appointed by the President. He allocates the portfolios among his ministers, and he can drop any minister or pick any minister into his cabinet. The Prime Minister presides over the meetings of all the Council of Ministers. He decides the policies of the government. He coordinates the work of different ministries and also solves interdepartmental conflicts. Prime Minister is also the chairperson of the Planning Commission of India, which is a key body in the process of planning. Prime Minister advises the President on all the important matters like appointments of the judges of High Courts, appointment of the judges of the Supreme Court, appointment of Chief Election Commissioner, appointment of Comptroller, appointment of Auditor General. He also advises the President on dissolving of the Lok Sabha and declaration of emergencies. So these are the various functions and powers of the Prime Minister of India. We shall see about Parliament. In the first part, Lok Sabha or the lower house of the Parliament. Lok Sabha is also called as the House of the People by the Constitution. It is the directly elected lower house of the Parliament of India. The members of Lok Sabha are directly elected through general elections by the people of India or by the citizens of India. As of 2019, there have been 17 Lok Sabha elected by the people of India. The constitution limits the Lok Sabha to a maximum of 552 members, including not more than 20 members representing the people from the Union territories, and 2 members shall be represented from the Anglo-Indian community. If the President feels that the Anglo-Indian community is not adequately represented in the House of the People. Currently, the size of the Lok Sabha has 552 members, including the Speaker and 2 appointed members. Each Lok Sabha is formed by a 5-year term. After this, it is automatically dissolved. So Lok Sabha is valid only for 5 years, and after 5 years, the elections will be repeated, unless it is extended by the proclamation of emergency, which may extend the term by 1 year, by 1 year increments. And 17th Lok Sabha was formed in the month of May year 2019. An exercise to redraw the Lok Sabha constituencies boundaries was carried out by the Delimitation Commission based on the India's census for 2001. However, this exercise that was supposed to be carried out after every census has been suspended in 1976 following the constitutional amendment in order to avoid the adverse effects of the family planning program that was being implemented. We shall see about the minimum membership qualifications for Lok Sabha. The membership of Lok Sabha requires that the person must be a citizen of India. He should have attained 25 years of age or above 25 years of age. He should be mentally sound. He should not be bankrupt, and also he should not have any criminal procedures against him. There are certain reserved seats. For these reserved seats, one shall be member of either the scheduled caste or the scheduled tribes. The sessions and the working hours of the Lok Sabha on normal business days starts from 11 am and up to 1 pm, and there will be a lunch break from 1 to 2, and again it starts at 2 pm to 6 pm. The first hour of every sitting is called as the question hour, during which the questions will be posed by the members and it will be assigned to the specific government ministries which are required to be answered at a fixed date and time in the future. The Lok Sabha shares its legislative power with the Rajya Sabha, except in the area of money bills, in which case the Lok Sabha has the ultimate authority. In case of money bill, it is only sent to Rajya Sabha for its recommendations, and in the case of other related issues, it is sent with the period of 14 days notice period. So if it is not returned within the span of 14 days time, it is considered as passed. If conflicting legislation is enacted by the two houses, or if there is a conflict between the two houses, then a joint sitting is held in order to resolve the differences. In such a session, the members of the Lok Sabha will generally prevail because the Lok Sabha includes more than twice the number of members as the Rajya Sabha. And every year there will be 3 sessions of Lok Sabha. They are the budget session that happens from February to May, the monsoon session that happens from July to September, and the winter session that happens from November to December. Next is Rajya Sabha. Rajya Sabha is also called as the upper house of the Parliament of India, or it is also called as the Council of States. Membership is limited to 250 members in Rajya Sabha, 12 of whom are chosen by the President of India for their expertise in specific art fields. The people who have given contributions in the field of art, literature, science, and social services are nominated by the President. These members are known as the nominated members. The remainder of the body or the remaining members are elected by state and territorial legislatures. The terms of office are for 6 years for the elected member, and with 1/3 of the members retiring once in every 2 years. That means the people are elected from the state legislatures, and every 2 years, once in 2 years, 1/3 the strength of the people will be re-elected or will be retiring. The Rajya Sabha meets in continuous session, and unlike the lower house of the parliament, that is the Lok Sabha, it is not subject to dissolution. The Rajya Sabha shares its legislative power with the Lok Sabha, except in the area of supply where Lok Sabha has the overriding power. In the case of conflicting legislatures, a joint sitting of both the houses of the parliament is held. However, since Lok Sabha has more than twice as many members than the Rajya Sabha, it holds de facto veto power in such joint sessions, and only 3 sessions till date have been held. The last one was for the passage of the anti-terror law, quota. The Vice President of India, currently it is Mr. M. Venkaiah Naidu, is the ex officio chairman of the Rajya Sabha. The deputy chairman of the Rajya Sabha, who is the elected from amongst its members, takes care of the day-to-day matters of the House in absence of the chairman. The Rajya Sabha held its first sitting on 13th May 1952, and Rajya Sabha should consist of not more than 250 members, that is 280 members representing the states and Union Territories 12 members nominated by the President, which comes up to 250. The Rajya Sabha is a permanent body and is not subject to dissolution, and seats are allotted in proportion to the population of the states. However, one third of the members retire every second year and they are replaced by newly elected members. Each member is elected for a period of 6 years. The Vice President of India is the ex officio chairman of Rajya Sabha. The House also elects a deputy chairman from among its members. Besides this, there is also a panel of vice chairmen in Rajya Sabha, and the senior-most minister who is member of Rajya Sabha will be appointed by the Prime Minister as the leader of the House. The officers of the Parliament. The chairman and the deputy chairman of the Council of States are the officers of the Parliament. The Vice President of India shall be the ex officio chairman of the Council of the States by default as per the Constitution. The Council of States shall, as soon as may be, choose a member of the Council to be a deputy chairman thereof, and so often as the office of the deputy chairman becomes vacant, the Council shall choose a new member or another member to be the deputy chairman thereof. Vacation and resignation and removal from the power of the office of the deputy chairman. A member who is holding the office of deputy chairman for the Council of the States or the Rajya Sabha or the upper house shall vacate his office if he ceases to be the member of the council. If he loses his membership to the house of the Council of States, then he loses his post of deputy chairman. And at time, by writing under his hand addressed to the chairman, that is the vice president, if he resigns from his office. So if he decides to resign from his office, in that case also he has to vacate the post of the deputy chairman, and he may be removed from his office by a resolution passed by the council by a majority of the then members of the council. So if the members of the council decide to remove him, then they can pass a resolution and it has to be accepted by the majority of the council members who are the members of the council at that particular juncture of time, provided that no resolution for the purpose of the clause C shall be moved unless at least 14 days of notice period has been given for the intention to move the resolution. So minimum of 14 days notice period is necessary for removal of the deputy chairman of the house. In this slide we shall see about the power of the deputy chairman or other person to perform the duties of the office of the deputy chairman or to act as a deputy chairman. While the office of the chairman is vacant or during any period when the vice president shall act or discharge or function as the president, the duties of the office shall be performed by the deputy chairman. Or if the office of deputy chairman is also vacant by such member of the Council of the States as the president may appoint for that purpose. During the absence of the chairman from any sitting of the Council of the States, that a deputy chairman, or if he is also absent, such person may also be determined by the rules of the procedure of the Council, or if no such person is present, such other person may be determined by the Council to act as the chairman. The chairman or the deputy chairman will not preside while a resolution for his removal from the office is under consideration. At any sitting of the Council of the States, when any resolution for the removal of the vice president from his office is under consideration, the chairman, or while any resolution for the removal of the deputy chairman from his office is under consideration, the deputy chairman will not, even though he is present, preside over the house for the provisions of clause 2 of article 91, and he shall apply in relation to every such sitting as they apply in relation to the sitting from which the chairman or other, or as the case may be, of the deputy chairman is absent. So the deputy chairman, if the resolution is being passed or introduced in the house for the removal of the deputy chairman, in that case only the chairman can chair the house. In point number 2, the chairman will have the right to speak or to take part in the proceedings of the Council of State while any resolution for the removal of the vice president from his office is under consideration in the council. But notwithstanding anything in Article 100 shall be entitled to vote at all on such resolution or any other matter during such proceedings. Just like how there is a chairman and deputy chairman for Rajya Sabha or the state legislative council, similarly there is a speaker and deputy speaker for the House of the People or for the Lok Sabha. So the House of the People shall as soon as may be choose 2 members of the House to be a speaker and a deputy speaker, and often as the office of the speaker or deputy speaker becomes vacant, they shall choose again a respective person for that office, and House shall choose another member to be a speaker or deputy speaker. The vacation and resignation of or removal from office of the speaker and the deputy speaker. So for Lok Sabha we have a speaker and a deputy speaker. A member who is holding office as speaker or deputy speaker of the House of the People shall vacate his office if he ceases or if he loses his seat as a member of the House of the People, or if he loses his seat to be the member of the Lok Sabha, or at any time by writing to the deputy speaker. If a speaker wishes to resign from his post, he can definitely do that by writing to the deputy speaker. And if deputy speaker wishes to resign, then he can address it to the speaker, or he can be removed from his office by a resolution of the House of the People passed by a majority of all the then members of the House. So if the members of the House wish to remove the speaker or the deputy speaker, they can very well do that, provided that no resolution for the purpose of the clause C shall be moved unless and at least 14 days of notice period is given. So at least 14 days of notice period is required for the intention of motion of the resolution for the removal of the speaker and the deputy speaker. Further, whenever the House of the People is dissolved, the speaker shall not vacate his office until immediately before the first meeting of the House of the People and after the dissolution. The power of the deputy speaker or other person to perform the duties of the office or to act as a speaker. When the office of speaker is vacant, the duties of the office shall be performed by the Deputy Speaker, or if the office of Deputy Speaker is also vacant, then by such member of the House of the People as the President may appoint for that purpose. During the absence of the Speaker from any sitting of the House of the People, the Deputy Speaker, or if he is also absent, then such person may be determined by the rules of procedures of the House. Or if no such person is present, then such other person may be determined by the House shall act as the Speaker. The Speaker or the Deputy Speaker will not preside while a resolution for his removal from the office is under consideration. At any sitting of the House of the People, while any resolution for the removal of the Speaker from his office is under consideration, the Speaker, or while any resolution for the removal of the Deputy Speaker from his house is under consideration, the Deputy Speaker will not, even though he is present, preside over the House. And the provisions for the clause 2 of Article 95 shall apply in relation to every such sitting as they apply in relation to a sitting from which the Speaker, or as the case may be, Deputy Speaker is absent. The Speaker will have the right to speak in and otherwise to take part in the proceedings of the House of the People, while any resolution for his removal from the office is under consideration. So Speaker cannot preside, but definitely he can take part in the discussions and proceedings of the House of the People when a resolution for his removal is happening. Notwithstanding anything in the Article 100 be entitled to vote only in the first instance, or any such resolution or any other matter during such proceedings, but not in the case of an equality of votes. The next is salaries and allowances of the chairman and deputy chairman and the speaker and deputy speaker. So there shall be the allowances and salaries shall be paid to the chairman and deputy chairman of the Council of States and to the speaker and deputy speaker of the House of the People, and such salaries and allowances may be respectively fixed by the Parliament by law, and until provision in that behalf is to be made, such salaries and allowances are specified in the second schedule. The Secretariat of Parliament. So each House of the Parliament will have a separate secretarial staff, provided that nothing in this clause will be construed as preventing the creation of posts of common to both the houses of the Parliament. And Parliament may by law regulate the recruitment and conditions of service of persons who are appointed to be the secretarial staff of either the Rajya Sabha or the Lok Sabha. Until provision is made by Parliament under clause 2, the President may, after consultation with the Speaker of the House of the People or the Chairman of the Council of the States, as the case may be, make rules regulating the recruitment and the conditions of service of such persons who are appointed to be the secretarial staff of the House of the People and or the Council of the States. And any rules so made shall have effect subject to the provisions of the law made under the said clause.